They are based on speculation and at times misrepresentation. To set the record straight, Germany has provided you with a set of core documents in the judges folder. I will refer you to these documents in relatively quick succession, but I will provide key points on the slides. I do so first to rebut Nicaragua's accusation that Germany had turned its back on the Palestinians. On this point, Nicaragua yesterday changed its pleading significantly. It now no longer seems to claim, as it has done in its application, that Germany, and I quote, halted its bilateral financial assistance to the Palestinians without further consideration early in the conflict, end of quote. Instead, Council yesterday acknowledged that Germany, and I quote again, is engaged in facilitating or improving humanitarian aid in Gaza and for its suffering people, end of quote. And we welcome this correction. However, Germany firmly rejects Nicaragua's characterization that this engagement is, and I quote again, a pathetic excuse, as Nicaragua claims. Mr. President, documents contained in Annexes 2 to 5 of the judges folder show how inaccurate this assertion is. Annex 2 brings together a list of statements by high-ranking German representatives, which reflect Germany's commitment to support Palestinians in Gaza from early on in the conflict. Let me take you to the first statement included in the list, made by Foreign Minister Baerbock on 19th October last year. You'll see it on the slide with its two key messages highlighted. One, the appointment of a senior German diplomat, Mrs. Daike-Potzel, as special envoy for Middle East humanitarian issues. You heard nothing about Mrs. Potzel and her work in Nicaragua's pleading yesterday. Nothing about 5 months of tireless humanitarian diplomacy. Nothing about her public and behind-the-scenes engagement to increase the flow of humanitarian assistance under extremely challenging conditions. Also on the slide, a pledge made on 19th October last year. A pledge that Germany, and I quote, stands ready, is prepared to provide comprehensive humanitarian assistance. A pledge on which Germany acted on the same day by allocating an additional 50 million euros in humanitarian assistance for the people in Gaza. Annex 3 gives us a fuller account of Germany's concrete contribution, and the central information is also on the slide. It contains figures from the UN Office for the Coordination of Humanitarian Affairs, OCHA. It lists support for the occupied territories by country. The chart for 2023 lists Germany as the largest international donor. And if you look at the chart for January to 31st March 2024, which is in Annex 4 and now also on the slide, you will see that Germany has remained the largest donor. Mr. President, Germany's total support for Palestine since early 2023 stands at 254.5 million euros in humanitarian assistance alone. Since 7th October 2023, rather than halting its support, Germany has more than tripled its humanitarian assistance to the Palestinians in the occupied territories. And Annex 5 highlights the real impact of Germany's commitment. I would ask you to consider this as you reflect on Nicaragua's characterization that this is just a pathetic excuse. Mr. President, members of the court, in addition to dismissing Germany's support, yesterday Counsel for Nicaragua accused Germany of having, and I quote, defunded UNRWA a decision that Nicaragua presents as the cutting off of aid at the most critical moment. This Nicaraguan claim is entirely without merit. Core information about what really happened is in Annex 6 to 9 of your folder. I will limit myself to 3 points. First, Germany has not defunded UNRWA. On 27th January, it took a temporary decision not to approve further funds to UNRWA operations in Gaza. This decision was taken in response to grave allegations that UNRWA staff were implicated in the terror attacks of 7th October. Allegations that left the UN Secretary General horrified and that continue to be investigated. Germany has since resumed its funding for UNRWA operations in the West Bank, Jordan and elsewhere, committing a further 45 million euros. And already on the 1st of March, the very day Nicaragua instituted proceedings, Germany agreed in consultation with other EU member states to release a 50 million euro emergency assistance package from European Union funds. 12.5 million euros of these funds are provided by Germany. But Nicaragua not only, and this is my second point, ignores this context. It ignores the fact that Germany's temporary decision of 27th January has had no direct effects on UNRWA operations. On 27th January, Germany was not due to release any funds for UNRWA for operations in Gaza that would have been withheld or withdrawn as a result of the decision. And this was made very clear in the statements announcing the decision, which you see on the slide. It includes the phrase, "There are no new funding decisions pending. Humanitarian assistance will continue." Put differently, not a single euro of support has been halted or withdrawn. Quite to the contrary, Germany honors its pledges. Funds provided before 27th January are still being used to support UNRWA work in Gaza. Third, quite apart from UNRWA, Germany has stepped up its support for Gaza. The information contained in Annex 10 of the Judges folder make this abundantly clear. Annex 10 lists relevant actions and decisions taken by Germany since the 27th of January. It is by no means exhaustive, but it shows what has really been happening. I will have to be very selective, but would urge you to look at Annex 10 when you consider Nicaragua's claims. And when you look, you will see that immediately after 27th January 2024, the German government made available support to other humanitarian donors, such as UNICEF, the ICRC, and the World Food Programme. An additional support now amounting to nearly 40 million euros, in addition to funds provided to UNRWA and to contributions via the EU and the regular UN budget. Annex 10 also highlights numerous examples of direct operational support aimed to alleviate the situation in Gaza. In-kind support, such as supplying hundreds of tons of medical and sanitary equipment to the Palestinian Red Crescent in February. Ongoing work behind the scenes to ensure that help provided by agencies actually reaches Gaza under the most difficult conditions. And as an emergency measure, airdrops, an initiative by the Jordanian government in which the German Air Force cooperates. 16 airdrops so far have landed 83 tons of food directly into Gaza, and another one is scheduled for today. It is plainly wrong to suggest that Germany has in any way turned its back on Palestine. Germany works with countless partners through various routes, leaving no stone unturned to alleviate the suffering. Mr. President, members of the Court, I turn to the second part of my presentation. Nicaragua accuses Germany of providing Israel with military aid and thereby facilitating breaches of international law. It says relatively little on how this equipment is supposedly used, and I will come back to this matter. Instead, Counsel for Nicaragua repeatedly mentioned the total volume of licensed exports in 2023, 326 million euros, and made references to items allegedly delivered, such as, and I quote, artillery shells and munitions. But the picture presented by Nicaragua is at best inaccurate, and at worst, it is a deliberate misrepresentation of the actual situation. Of course, Germany and Israel have close ties, including in defense cooperation. Germany's responsibility for Israel's security, emphasized by Germany's agent just now in her opening statement, is an important factor in this respect. But this cooperation is based on a robust legal framework that assesses export licensing requests on a case-by-case basis, and that ensures compliance with national law and Germany's international obligations. And if we look at what has actually been licensed for export to Israel under this framework since October 2023, we see no artillery shells, no munitions. Nearly all exports involve what is known as other military equipment, typically of a subordinate or defensive nature. Mr. President, permit me to begin with a comment about the German framework governing exports of military equipment, about which you have heard nothing from Nicaragua. This is a robust framework. All German exports of military technology and equipment to Israel are subject to strict licensing requirements. Among these, German law distinguishes between two categories: war weapons, Kriegswaffen, and other military equipment, sonstige Rüstungsgüter in the original German. War weapons comprise, for example, combat aircraft or tanks, but also automatic weapons and certain corresponding ammunition and essential components. These war weapons require two licenses before export, under the War Weapons Control Act and under the Foreign Trade and Payments Act. The other category, other military equipment, is broad. It goes much beyond weaponry in the usual sense. It includes, for example, defense equipment against chemical hazards, protective gear such as helmets or body protection plates, communication equipment, camouflage paint, and components, parts, and other equipment of a subordinate character. Outside standardized categories for routine deliveries, not only war weapons, but also all other military equipment under German law requires an individual license for export. And such individual license can only be granted following a case-by-case assessment of an individual application on the basis of binding criteria. We have provided in Annex 11 to 18 of the Judges folder relevant excerpts of the applicable German laws, but also of the 2008 EU Council Common Position defining common rules governing control of exports of military technology and equipment, and the Arms Trade Treaty. Professor Peters will take you to these. At this stage, permit me to make a threshold point. For every license that is granted, the German government carefully assesses whether there is a clear risk that the particular item subject to licensing would be used in the commission of genocide, crimes against humanity, or grave breaches of the Geneva Conventions of 1949. This requirement follows from binding rules of German and European law, which exceed international requirements. As Professor Peters and Palchetti will illustrate, the scrutiny is detailed, and it involves an interagency process with consideration by at least two ministries: the Federal Ministry for Economic Affairs and Climate Action and the Federal Foreign Office. And depending on the content of the license application, potentially also the Ministry of Defense and the Federal Chancellery, the Federal Ministry for Economic Cooperation and Development, the Federal Ministry of Finance, the Federal Ministry of the Interior and Community, and the Federal Ministry of Justice. As regards these war weapons, licenses must be issued at the ministerial level and accompanied by a corresponding additional license issued by the Federal Office for Economic Affairs and Export Control. Mr. President, what military equipment has Germany licensed? Military exports, of course, are a highly sensitive matter. Nonetheless, Germany has made a sincere effort to provide you with information that allows you to scrutinize Nicaragua's assertions. We have included core figures provided by government departments involved in the licensing process in Annex 19 of the judge's folder. Let me highlight 3 points before commenting on particular accusations that Nicaragua made yesterday. My first comment concerns the central categories of military equipment distinguished under German law, which I've mentioned already. War weapons, including ammunition and essential components on the one hand, and other military equipment on the other. This is an important distinction because the risks associated with the export of war weapons are naturally much higher, which is a central factor in deciding on licenses. Nicaragua was very brief on this distinction. From the slide, you see what Nicaragua omitted. 98% of the licenses granted since 7th October 2023 did not concern war weapons, but other military equipment. In 4 instances only has Germany eventually licensed the export of war weapons since October 2023. And this is the first relevant point of context if we want to appreciate the actual licensing practice. My second point, which also appears from document 19 and on which Nicaragua again was completely silent, concerns this. If we look at the statistics that Nicaragua presented to you, we see that over 25% of the volume of exports were never destined for final use in Israel. Licenses worth around 85 million euros concern military equipment that is to be processed in Israel and then re-imported to Germany, re-imported for use by the German armed forces. Yet this equipment features in the statistic that Nicaragua relies on to make its accusations. And my third point, the temporal context, another crucial factor, as the risks are being assessed not just with respect to particular military goods, but also at a particular point in time, in light of circumstances obtaining then. Nicaragua yesterday sought to make you think that there had been no evolution. Professor Pelé asserted that Germany
continues to authorize large-scale delivery of weapons.
In response, let me ask you to look at the following slide. It shows how the total value of exports for war weapons and for other military equipment to Israel since October 2023 is spread out over the past months. The exact figures again are in Annex 19 of the judge's folder. but the basic point emerges clearly from the slide. Almost 80% of the volume of exports was approved before the end of October 2023, in what this court has referred to as the immediate context of Hamas's horrendous massacres. At that point, and in this dramatic situation, Germany decided to prioritize pending license requests. Following October, the total volume of exports has dropped sharply, and you see the figures on the slide, to 24 million, 19 million, 8.5 million, and so on. For now, permit me to mention two salient aspects. The first is this. In February and March 2024, the total volume of exports for war weapons and other military equipment, the volume of exports approved by Germany, was at around 500,000 and around 1 million euros respectively. These licenses were issued for lenses for daylight observation binoculars, bonding devices for hydrogen storage on submarines, and infrared protection systems for defense against guided missiles. The most recent license, and this is my second particular point, was granted on the 8th of March 2024. It concerned a slip ring for the installation of a radar system. This is not an item that could plausibly be used to commit war crimes. A limited number of requests for exports remain under review for the time being. They are reviewed by German authorities in light of the developing situation and of the potential impact that the particular item might have. Mr. President, this brings me to the end of my overview of what exports have actually been licensed since October. Permit me to conclude by responding to three specific accusations that Nicaragua made yesterday. And they concern particularly military items that, according to Nicaragua, Germany has delivered to Israel. But I begin by responding to points raised by Council yesterday, who noted that quite apart from exports of military equipment, Germany had supplied military equipment directly to Israel, government to government, and specifically in that respect mentioned a request for tank ammunition. Mr. President, we have verified this with the German ministry yesterday. Based on the information I received, I can confirm that Israel approached the German government in 2023 for tank ammunition. This application is being scrutinized. No license has been approved. In fact, and this goes to Nicaragua's broader insinuation yesterday, the only items directly supplied from the German Bundeswehr, armed forces, to Israel are sanitary material and helmets. Nicaragua's second specific allegation made yesterday concerns war weapons allegedly licensed for export. Nicaragua yesterday repeated points made in the application, namely that Germany had provided Israel with, I quote, all type of military aid that would be used to commit grave crimes under international law, such as anti-tank weapons, ammunition for machine guns, and propellant charges. I have already mentioned that since October 2023, 4 licenses for war weapons have been granted. But Nicaragua completely misrepresents what they covered. 2 of these licenses indeed concerned ammunition, as Nicaragua notes. 500 pieces of ammunition were approved in November, a further 1,000 pieces approved in early 2024, both for industrial cooperation. What Nicaragua does not say is that the license was for training ammunition. Training ammunition that is, as German exports involved in the licensing process confirmed, not suitable for combat operation. The third license concerns propellant charges, again, as Nicaragua notes, also granted in connection with the cooperation project between German and Israeli industry. But again, Nicaragua omits the key bit of information. The propellant charges were for test purposes. Most of the propellant charges licensed for export are to be destroyed in Israel. The rest is to be redelivered to Germany. So to reiterate, 3 of the 4 final export licenses for war weapons concerned items that are unsuitable for use in combat operations. The 4th license, which was in the immediate context of Hamas massacres, concerned the export of 3,000 portable anti-tank weapons. Finally, to complete the picture, let me add in full transparency that for one further military item, 1 license has been granted. This is a submarine which has received 1 license, as I mentioned, but as a war weapons requires 2 licenses for export. So 4 war weapons licensed for export, 3 of them for test and training purposes, and 1 submarine not yet approved for export. That is the outcome of the actual licensing practice since October 2023. Nicaragua's references yesterday, referring to artillery shells or to munitions that would be used in Gaza, simply bear no relation to reality. Germany rejects them. Mr. President, my final point concerns the Heron drones, unmanned vehicles. They featured prominently in Nicaragua's application as well as in its presentation yesterday. Germany stands accused of having handed over 2 Heron drones to Israel, and Counsel for Nicaragua insisted on the point yesterday, noting, and I quote, that the destruction caused by the unmanned aerial vehicles like these drones had been widely reported, end of quote. Again, Nicaragua's assertions are false. The truth about the Heron drones can be found in the document in Annex 20 of the folder, and the essence is this. The 2 Heron drones are Israeli drones. They are owned by Israel, not Germany. At no point have they left Israel. German soldiers were trained on them while in Israel under a lease agreement, which specified Israeli ownership and control. While German soldiers trained on these drones, the Heron drones were unarmed. After 7th October, German military personnel left Israel, as their security could not be guaranteed, and so the training on Israeli soil temporarily ended. This is the context. Nicaragua is again wrong on the basic facts. Mr. President, to sum up, 98% of the licenses granted after 7th October do not concern war weapons, but other military equipment. Over 25% of this military equipment is destined for eventual re-importation and used by the German armed forces. 80% of the volume that was approved for export was approved in October 2023. Applications for export licenses are scrutinized by different ministries by reference to conditions that are more stringent than those under international law. As a matter of fact, only 4 war weapons have been licensed for export since October 2023, 3 of which concern test or practice equipment. Finally, as regards humanitarian assistance, Germany continues to provide humanitarian support every single day under extremely difficult conditions, constructively engaging with international partners. The minute we look closely, Nicaragua's accusations fall apart. This, Mr. President, members of the Court, concludes my presentation on the factual background to the present dispute. I'm grateful for your kind attention, and I would ask you now, Mr. President, to invite Mr. Sam Wordsworth to the podium to continue Germany's presentation.
I thank Mr. Stamps for his statement. I now invite Mr. Samuel Wordsworth to take the floor.
You have the floor, sir.
President, members of the Court, it is a privilege to appear before you and to have been asked by Germany to set out its position that no order on provisional measures can be made given the absence of prima facie jurisdiction and/or a prima facie basis for any exercise of jurisdiction. Germany makes 2 points. First, it is plain from the application, and was no less plain yesterday, that alleged violations of international law by Israel constitute the essential bedrock of Nicaragua's application and request. The Honourable Agent's first speech yesterday was replete with assertions that serious breaches of international humanitarian law and other peremptory norms of international law, including genocide, are taking place in Palestine, alongside references to the genocide committed by Israel. The case on genocide against Germany is entirely dependent upon this, that is, upon a prior finding of breach by Israel. The same applies to Nicaragua's case on international humanitarian law. The agent summarised this claim as follows: the violations of international humanitarian law by Israel create obligations for Germany. I'll return to the details in a moment, but the basic point is that Nicaragua seeks determinations on the conduct of Israel, an absent party, which determinations are a prerequisite to any finding of responsibility on the part of Germany. Yet, Nicaragua must establish that at least prima facie the court is able to exercise jurisdiction, and it cannot do so given the manifest absence of an indispensable third party, namely Israel. Second, it was said by the agent yesterday that Nicaragua has not had the opportunity to be informed of the position of Germany. Yet the reason for this is Nicaragua's decision to lodge its application without allowing Germany an opportunity to engage and to inform Nicaragua of the basic factual inaccuracies that Professor Tams has just spelt out. Instead, just 17 days after Germany received Nicaragua's note verbale, the current proceedings were commenced without prior warning, relying for the supposed existence of a dispute on a few words by a governmental representative in a general press conference where Germany was seeking to withhold its position because it had then only seen a short press statement from Nicaragua concerning the alleged conduct of 4 states, one of which was Germany. Nicaragua sought to skate over this issue yesterday, but it cannot show even prima facie the existence of the dispute required to establish the court's jurisdiction. Turning to the details, I start with the central need in this case for determinations by the court concerning the conduct of Israel, an absent party. Nicaragua showed itself yesterday to be very sensitive about this, with Professor Pelley seeking to neutralise this key point. First, by saying that at the provisional measures phase, the court is only concerned with the prima facie existence of jurisdiction, not the ability to exercise it, and then by suggesting that the monetary gold line of jurisprudence made no sense. Neither contention is remotely serious. First, at the provisional measures phase, the court will of course examine both the existence of prima facie jurisdiction and the issue of whether, Prima facie, it is able to exercise jurisdiction. No authority was cited to suggest the contrary, and indeed, any different approach would be entirely counterintuitive. The long-standing purpose of provisional measures is to preserve by such measures the rights which may be subsequently adjudged by the court to belong either to the applicant or to the respondent. It makes no difference at all whether the reason for there being no ability to adjudicate on relevant rights is due to absence of jurisdiction or absence of the ability to exercise jurisdiction. Moreover, Nicaragua's contention is flatly inconsistent with the court's established jurisprudence. In the Gambia and Myanmar case, for example, as you can see on your screens, the court was not content simply to establish its jurisdiction prima facie, as it did at paragraph 7 of the order, but it then went on to consider a disputed issue of admissibility, in that case one of standing. Second, the monetary gold-type situation is not wholly exceptional, as was suggested yesterday, and the approach of the court there, or in East Timor, for example, does no more than reflect the basic rule on the essential need for consent. This is to be found in many other contexts, including, for example, maritime delimitation, where the court has held, as one would expect, that it will not rule on an issue when, in order to do so, the rights of a third party that is not before it have to be determined. It is obviously wrong to say that there is no need for such an approach, given Article 59 of the statute and the possibility of intervention, and the current request offers an apt example in this respect. Suppose the court were to make an order in the terms sought by Nicaragua on the basis of the allegedly plausible rights under the Genocide and Geneva Conventions, which presuppose that Israel is in breach of these treaties, or at least that there is a serious risk of such breach. Such a finding would be treated around the world as a generally applicable and objective assessment of actual or likely wrongful conduct by Israel. Yet Israel would have no standing to challenge the order. If Israel wished to see the order amended or lifted, it would have to intervene as a party under Article 62 of the statute. But it could only do so with the consent of both parties, given the absence of a jurisdictional link so far as concerns Nicaragua's claims of breach of IHL. Thus, not only does the claim put forward by Nicaragua seek determinations on the lawfulness of Israel's conduct that will directly impact Israel, it leaves Israel without any avenue to challenge those determinations, save for submission to the court's jurisdiction, with a critical key to even being able to challenge any order held by Nicaragua, given the need for its consent to intervention. Thus, Nicaragua seeks radically to undermine the most fundamental principles concerning consent to jurisdiction. I turn to the further points made by Professor Pele. The first was simply to repeat the contention that the issue of the exercise of jurisdiction does not arise at the provisional measures phase. As he said, there will be no determination on the merits. I say no more on that, other than to recall that issues going to jurisdiction are assessed prima facie by reference to whether the court will be able to make a judgment specifically on the merits, not by looking at the provisional measures phase in isolation. It could not be otherwise. As a second point, it was argued that the current case is one where the legal interests of a third state might be affected, but no more, and hence the principle in monetary gold is not engaged. It was said that no demand was made impacting the rights of a third state, and that the reference point had to be Nicaragua's application, from which it is said to be clear that the issue is not whether Israel has breached its international obligations, but indeed whether Germany has breached its own. While the fundamental rules on consent could not, in any event, be bypassed by attempts at artful pleading, it is useful to focus on Nicaragua's application. This shows that the essential keystone in the construct of the current claim is the unlawful nature in which Israel is said to be pursuing its current military operations in Gaza. This is plain, for example, from paragraphs 8 to 9 of the application, where it is asserted that actions by the Israeli government constituted serious breaches of universally accepted peremptory norms of international law, and that serious violations of international humanitarian law were evident from the start. The responsibility of Germany is alleged, but in complete reliance on asserted wrongful acts of Israel. This can be seen, for example, from paragraph 38 of the application. Now on your screen, you can see how this works. The German government has engaged in political, military, and financial support to Israel, despite its awareness that the military operation launched in the OPT, particularly Gaza, was being conducted in complete disregard of international humanitarian law, human rights law, and the Genocide Convention. Then a few lines down, Germany has not acted to bring to an end the wrongful acts of Israel perpetrated against the Palestinians, and has instead supported Israel by providing it with all types of aid, including military aid, that would be used to commit grave crimes under international law. Turning then to the specific declarations sought from the court, paragraph 67 of the application, Nicaragua first alleges that Germany has breached Article 1 of the Genocide Convention through a failure to prevent genocide. But in order to determine that there has been such a breach, the court must first determine that Israel has committed genocide. This can be seen, for example, from the Bosnian genocide case. And please note that this is the paragraph that Nicaragua put up on the screen yesterday, but omitting the passages underlined on the screen, despite their obvious importance. In particular, a state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. The passage read out by Nicaragua is in italics. The court there emphasizes that it is not saying that there is no obligation of prevention until the perpetration of genocide commences, but the court is clear on the need for a prior finding on genocide before any breach of the obligation to prevent can be determined. And this is reiterated in the second underlined paragraph. If neither genocide nor any of the other acts listed in Article 3 of the Convention are ultimately carried out, then a state that omitted to act when it could have done so cannot be held responsible a posteriori, since the event did not happen, which under the rules set out above must occur for there to be a violation of the obligation to prevent. The same basic point follows from the Croatia and Serbia case. The court found that no genocide had taken place, and hence there could not be any question of responsibility for a failure to prevent genocide, a failure to punish genocide, or complicity in genocide. Turning back to the application, Nicaragua then alleges that Germany has aided and assisted Israel in the commission of genocide and breaches of obligations under international humanitarian law at paragraph 67.3 and 67.2 and 3. And these allegations, again, cannot be determined without a prior determination that the conduct of Israel is unlawful. Article 16 of the ILC Articles on State Responsibility, which the Court has considered to be reflective of customary international law, is concerned with aid or assistance in the commission of an internationally wrongful act. There must be an internationally wrongful act. The commentary further clarifies that this must be a completed act. And that, of course, is only confirmed by the subsequent conclusion of the court on complicity in the Croatia and Serbia case that you've just seen. Moreover, the ILC commentary expressly notes the International Court has repeatedly affirmed that it cannot decide on the international responsibility of a state if, in order to do so, it would have to rule as a prerequisite on the lawfulness of the conduct of another state, in the latter's absence and without its consent. This is the so-called monetary gold principle. That principle may well apply to cases under Article 16, since it is of the essence of the responsibility of the aiding or assisting state that the aided or assisted state itself committed, and please note there the use of the past tense, an internationally wrongful act. The commentary does suggest that the monetary gold principle may not be a barrier to judicial proceedings in every case, and indeed there may, in a given case, already be the requisite prior finding, or indeed the consent from the third state. But in the current case, monetary gold does indeed apply, and I'll return to the case and its application shortly. As to the declaration sought at paragraphs 67.3 and 67.4 of the application for breach of Common Article 1 and related customary international law due to a failure to ensure compliance, a breach of the obligation to ensure respect in all circumstances is necessarily predicated on there having been a lack of the required respect by the other state. The reasoning of the court in the Bosnian genocide case applies equally in the current context. There, as you've seen, the court explained how the state's obligation to prevent and the corresponding duty to act arises when the state learns of the existence of a serious risk of genocide, which is exactly the same as how Nicaragua portrays the operation of Common Article 1. But, as the court also explained, a genocide must occur for there to be a violation of the obligation to prevent. Precisely the same applies here, and it makes no difference at all if Common Article 1 is envisaged as a rule of due diligence, as that is just how the obligation to prevent under the Genocide Convention is interpreted. The basic question remains: how can it be said that there was a failure to ensure respect of a third state if the failure on the part of that third state to respect is not established in the first place? I would add that this is how the court envisaged the operation of this obligation in its 1986 judgment in Nicaragua and USA. And that is also the intuitive result. It is entirely usual for one state to support another in the context of an armed conflict. And this is not an activity that the international community rigidly seeks to deter. It is only if the conduct of the conflict turns out to have been in breach of international humanitarian law that the acts of the state offering support would be expected to be ruled upon. The same basic points apply to paragraph 67(5) of the application, which is predicated on Israel denying Palestine's right to self-determination and maintaining and imposing an apartheid regime. As to the court's jurisprudence, the current case is substantially the same as monetary gold. There, the court explained, the court is not merely called upon to say whether the gold should be delivered to Italy or to the United Kingdom. It is requested to determine first certain legal questions, upon the solution of which depends the delivery of the gold. Or just so here, the court is not merely called upon to pronounce on the state responsibility of Germany. It is required first to make determinations as to the responsibility of Israel. And Nicaragua cannot avoid this by saying that the court can find breach by Germany on the basis of a serious risk of a breach by Israel. On the correct analysis, such determinations would not be sufficient to establish breach by Germany, as follows from the analogy to the Bosnian genocide case. But anyway, as a matter of principle, it makes no difference whether the required determination is of actual breach or of serious risk of breach. There is still an essential prior determination of the conduct of an absent third state, on which the responsibility of the respondent state wholly depends. The consequent reasoning of the court in monetary gold concerning the absence of jurisdiction regarding the underlying issue of breach by Albania thus applies in the current context. In the determination of these questions, questions which relate to the lawful or unlawful character of certain actions of Albania vis-à-vis Italy, only two states, Italy and Albania, are directly interested. Or just so here, substituting Israel for Albania and Nicaragua for Italy. To go into the merits of such questions would be to decide a dispute between Italy and Albania. The court cannot decide such a dispute without the consent of Albania. And this is not a case like Nauru, where the determinations with respect to Australia's conduct merely might have had implications for the legal situation of the UK and New Zealand. And the court was in a position to hold that no finding in respect of that legal situation will be needed as a basis for the court's decision on Nauru's claims against Australia. By contrast, the current case is precisely analogous to East Timor, where Portugal's claim as to the unlawfulness of Australia's conduct in entering into the 1989 treaty with Indonesia could not be assessed without first entering into the question why it is that Indonesia could not lawfully have concluded the 1989 treaty. Again, the current case is on all fours. I turn to the existence of a dispute, which is a basic prerequisite to consent to jurisdiction under both Article 9 of the Genocide Convention and Article 36(2) of the Court Statute. The dispute that is relied on must exist objectively at the time the court is seized. Equally well established is the need for a claim of one party that is positively opposed by another, and that the two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. As to the basic facts in this case, Nicaragua relies on its press release of 1st February 2024 and a note verbal attaching a letter of 2nd February, as well as the excerpts from a wide-ranging German governmental press conference of 7th February. So, Nicaragua says claim plus opposition, hence a dispute. But as the court has explained, the question of whether there is a dispute or not is one of substance, not of form. This is not a box-ticking exercise, as can be seen from the court's very detailed consideration in past cases as to whether there was indeed the required dispute with respect to the asserted source of jurisdiction. And in considering substance, the context is of critical importance. The current parties are at 2 points of remove from the classic bilateral dispute situation. Nicaragua appears in this case only on the basis of alleged erga omnes obligations owed by Germany, which is not, of course, a participant in the ongoing conflict in Gaza. And this is not a case where the parties had already locked horns before the United Nations or in some other fora. In the current situation, for there to be a dispute as a matter of substance, there would have to be some form of meaningful engagement with a claim, pursuant to which Germany communicated its position either to Nicaragua or in such a way that it could objectively be understood as crystallizing a dispute. It was said yesterday that the legal dispute was described in Nicaragua's letter of 2nd February 2024. But this note verbal was sent to the public information email address of Germany's permanent mission to the United Nations in New York, not any address that is used for official diplomatic communications. It was not picked up until the 13th of February, and it should be noted that equivalent note verbal were also sent to the public information email addresses for Canada, the Netherlands and the United Kingdom. And we understand that these were likewise only picked up on 13th February following a further email sent by Nicaragua to the Netherlands. This approach of Nicaragua is, to say the least, unusual. And indeed, in the past, Nicaragua has always sent note verbal to the appropriate email addresses of the ambassador and assistants at the German embassy in Managua, often copying in other German missions, again on the appropriate email addresses. It follows that when, at a general press conference of 7th February, a representative of the German Federal Foreign Office was asked questions about having received a note verbal and how Germany intended to respond, Germany was simply not in a position to say anything material. The excerpt of the press release is at Judges Folder, tab 21, and in due course, I ask you to read this carefully. You will see that the journalist asking the questions correctly understood Germany as not having received any note verbal. And you will also see that Germany did not consider itself ready to make any public statement of its position. This was not and could not have been a response crystallizing a dispute on the basis of a claim in a note verbal that had not been seen. Once it had in fact received the note verbal, Germany was actively considering its response and seeking coordination with the 3 states that had received similar emails when, without warning, Nicaragua commenced the current proceedings on 1st March. There was no opportunity to engage, and it is to be emphasized that this is not a case like Gambia and Myanmar, where the court could infer the existence of a dispute following a failure to respond 1 month following the delivery of a note verbal, but in circumstances where there had already been a number of prior communications, both outside and within the UN General Assembly, that showed the mutual opposition of views. Nicaragua sought to suggest, but was wholly unable to point to, anything remotely equivalent, and notably seeks to invoke the German note verbal of 11th March sent to the court after it was seized. And that, of course, is wholly irrelevant. Of course, the court is only concerned with a prima facie showing, but the fact that this case is at the provisional measures phase cuts both ways. It is not just that extraordinary relief is sought, given that jurisdiction and the ability to exercise jurisdiction have not yet been established. Also, relief is sought on the basis that Germany, a peaceful democratic nation, a long time avowed supporter of international law and the international legal order, is breaching the Genocide Convention and conventional and customary international law. The determination sought could scarcely be more serious, and the relief sought also has and is plainly intended to have direct and indirect impacts on third states not before the court. It is precisely in circumstances such as this that jurisdiction prima facie demands a real showing of positive opposition and clearly opposed views, not a precipitate rush to court in the hope that a box might be considered at best half-ticked. Mr. President, members of the Court, I thank you for your attention and ask you to call Professor Peters to the floor.
I thank Mr. Wordsworth for his statement. I now invite Mr. Anne Peters to the floor. You have the floor, madam.
Mr. President, members of the Court, it is an honor for me to appear before you and to present Germany's position on plausibility. This court has already been seized in another case to deal with heartbreaking consequences of the armed conflict in Gaza initiated by the brutal attack of Hamas on Israel. But this case is not between the two parties to that armed conflict. Here, this is the first case in the court's history in which provisional measures are sought against a state that stands accused of complicity in and lack of vigilance and prevention of acts of another state that is not party to this proceedings. Both types of legal obligations arise exclusively and necessarily in connection with or in response to the conduct of another state that is absent from these proceedings. Mr. Wordsworth has already demonstrated how this poses a serious admissibility problem. This attempt to request provisional measures against one state by reference to the conduct of another state stretches the plausibility assessment to breaking point in an unprecedented manner. This court will first have to find, on the basis of evidence, that there are plausible facts that establish plausible violations on the part of Israel. Second, the court will have to find that there are plausible facts that establish plausible violations on the part of Germany. Here, the court will especially have to establish whether there are plausible objective and subjective links between the conduct of Germany and the conduct of the absent third state, Israel. In this novel and special constellation, one would have expected Nicaragua to adduce concrete evidence and legal reasoning to substantiate its claims against Germany. However, Nicaragua has said surprisingly little on the law, and as regards the facts, it has almost exclusively relied on speculation and inferences. Nicaragua claims that Germany is complicit in genocide and violations of international humanitarian law allegedly committed by Israel. In paragraph 15 of the application, the applicant mentions German, I quote, involvement in the facilitation of unlawful activities concerning the laws of war. And in paragraph 16, the applicant alleges that Germany is facilitating the commission of genocide and calls this a distinct base of Germany's responsibility. This must fail because the most basic prerequisites for establishing aid and assistance, or what's really the same thing, complicity, are lacking. These prerequisites are a causal contribution of the accomplice to the wrongful act, and knowledge and intention to facilitate the wrongful act of the main perpetrator. Nicaragua has not and cannot provide any evidence to show these elements to be plausible. The standard requirement for causality in law, as applied by international tribunals, is that there must be proximity, directness, or that the breach must not be too remote. Proximity is established where the consequence of an act is a natural and normal consequence. Such a link is especially needed to establish aid and assistance. Aid and assistance must have contributed significantly to the alleged wrongful act. This can only be determined objectively by assessing the quality and the quantity of the real contribution in the concrete case. Nicaragua has offered no evidence as to how any of the military equipment from Germany could have made a significant contribution to an alleged genocide or to breaches of IHL. Given Germany's stringent licensing standards that scrutinize precisely these risks, there is no indication that German equipment would have naturally or normally led to plausible violations of international law by Israel. In addition, Nicaragua has not provided any evidence for the presence of the necessary subjective elements, which are knowledge and intent. In the Bosnian genocide case, you insisted that the conduct of an organ or person furnishing aid or assistance to a perpetrator of the crime of genocide cannot be treated as complicity in genocide unless, at the least, that organ or person acted knowingly, that is to say, in particular, was aware of the specific intent dolus specialis of the principal perpetrator. If that condition is not fulfilled, that is sufficient to exclude the categorization of the conduct as complicity. The position is the same in customary law generally. Aid and assistance must be given with knowledge of the circumstances and with the intention to facilitate the occurrence of the wrongful act. Nicaragua has not provided evidence on any plausible intent on the part of Germany to facilitate internationally wrongful acts. Germany, on the contrary, has demonstrated to this court that its intention has always been to assure full respect of international law, be it the Genocide Convention, international humanitarian law, or other customary law. Germany has engaged with Israel on numerous occasions to urge compliance. As explained by Professor Tams, Germany has a robust legal framework and procedures in place with regard to arms exports. These procedures have been and will continue to be applied. With regard to humanitarian aid, Germany has, contrary to the allegations by Nicaragua, increased its efforts significantly. Given these facts, any allegation of intention to facilitate the perpetration of allegedly wrongful acts by Israel is unfounded. Because the elements of aid and assistance are absent, all claims that Germany has aided and assisted in maintaining a situation resulting from alleged serious breaches of use organs by Israel, as Article 41, Section 2 of the Articles on State Responsibility put it, are equally baseless. I now turn to Germany's obligations under Article 1 of the Genocide Convention and Common Article 1 of the Geneva Conventions. Although, generally speaking, obligations to prevent genocide and to ensure respect with IHL are indeed Germany's own obligations. Nevertheless, the emergence of these obligations, the scope, the exact content, and any possible breach of such obligations inevitably depend on, and they also vary by reference to the degree and to the kind of the risk of wrongful acts by another state, in this case Israel. Allow me to start with the obligation to prevent genocide. That is an obligation of conduct that is incumbent upon all states. Germany is, of course, fully aware of the diverging views over the legal categorization of the Israeli conduct in its defense against the ongoing attack by Hamas. The court has been seized to judge upon this question in another case, not this one. In the current context, it should be noted that Germany has continuously
military aid that would be used to commit grave crimes under international law. Turning then to the specific declarations sought from the court, paragraph 67 of the application, Nicaragua first alleges that Germany has breached Article 1 of the genocide convention through a failure to prevent genocide. But in order to determine that there has been such a breach, the court must first determine that Israel has committed genocide. This can be seen, for example, from Bosnian genocide case. This is a paragraph that Nicaragua put on yesterday, admitting that is underlined from its obvious importance. In particular, a state can be held responsible for breaching a breach of genocide only if genocide was actually committed. The fact that Nicaragua is in the text, court there emphasises it's not an obligation to prevent until the genocide committed, but the court is going to free prior finding on genocide for any breach of obligation to prevent or deter. This is reiterated in the second underlying paragraph. If neither side of other aspects of the convention are carried out, the state committed to act that could have cannot be responsible or did not happen, which under the rules set out must occur that the obligation to prevent. The same basis follows from the Croatians. Yes, found no genocide to take place. There could not be a question of responsibility for a failure to prevent genocide, affect high genocide, or complicity in genocide. To make the application, Nicaragua alleges that Germany had assisted in the commission of genocide, breaches obligations under international humanitarian law, paragraph 67.3 and 67.2 and 3. And these allegations, again, cannot be determination the conduct of international law. Article 16 of the ILC articles on civil responsibility, which the court has considered to be reflective of international law, is concerned or assist in the commission of an internationally lawful act. There must be an internationally lawful act. The commentary further clarifies that this be a complete act. That must be confirmed by the subsequent report on complicity in the Croatian States, the GRC. What the ILC contracts, the report is referred it cannot decide the international possibility of a state. In order to do so, it would have to rule as a prerequisite the laws of the diversity, the last substance, and the international principle. That principle, which is Article 16, this is the essence of the responsibility of the state. The aided or assisted is self-permitted and plead their use of past tense and internationally lawful act. The country does test that the monetary principle may not be a barrier to judicial proceedings. Yes, indeed, may, in the case, or may be requisite by funding, or indeed the consent from a third state. In the current case, monetary proceedings will return the case and discuss shortly. And Regulations of paragraphs 63, 64 of the application for each Article 1 related to international law to ensure compliance. Breach the obligation to ensure respect in all circumstances is necessarily predicated on having the lack of required respect by the state. Neither the court nor the society applies to the current context. There, as you see in court Spain, the corresponding issue fact arises to a state that the existence is serious of genocide. Exactly the same as the Nicaragua treaty of war. But the court also explains that genocide must occur without a violation of the obligation to prevent. Precisely, there's no difference at all between is envisaged or due diligence. That is just an obligation to prevent, but as such is interpreted. The basic question is how could it say that there was a failure to ensure respect of that state if the failure of half that state to respect is not established in the first? But that is the court visit operation of the obligation in 1986 by Nicaragua and USA. And that's the intuitive result. It is entirely useful for one state to support in the context of an conflict. It is not active to the international community really seeks to turn. It is only the conduct of the conflict that is to be in breach of international humanitarian law that the acts of the state offering support be expected to be ruled on. Take a sick point up to 65 definition, which is a determination to maintain an imposing and harsh regime. As to the court's conclusions, the current case is mentioned as a court. There, the court explained, the court is not the court to say that the left of state or the kingdom. It is to determine first certain legal questions on the solution of which depends on the result. Just so the court is not the court on the responsibility of voting. It is required first to be determination of the responsibility of Israel. Nicaragua cannot say the court can find breach on the basis of risk of Israel. On the correct analysis, such determination would not be sufficient to establish breach Germany as follows from the entire case. As a matter it makes sense that the requirement is a dual breach or serious breach. There is still essential determination of the consequence of that state on responsibility to respond to the state wholly events. The reasoning of the court neutral gold, because in the absence of jurisdiction regarding a breach by Baker, that's fine in respect of that legal situation will be needed as a basis for the court's decision on Nauru's claims against Australia. By contrast, the current case is precisely analogous to East Timor, where Portugal's claim as to the unlawfulness of Australia's conduct in entering into the 1989 treaty with Indonesia could not be assessed without first entering into the question why it is Indonesia could not lawfully conclude the 1989 treaty. Again, the country of course. Which basically reflects jurisdiction of our genocide and Article 36 of course section. Dispute that the must exist actually at high proceeds. Equally well established is the need for what is positively opposed and that the two sides must hold clearly off concerning the question of performance or non-performance of certain international issues. This is the basic facts in this case. Nicaragua relies on its 1st February 2024 and a note of as well as the expert exercise for the German press conference of 7th February. So Nicaragua has to play opposition heads of dispute. The court has explained the question of dispute or not one of substance or form. It is not a boxing exercise, as can be seen with all very detailed consideration of past cases, so there was indeed the required dispute to respect exert all jurisdiction. Considering substance, the context is important. The current party are at 2 points of move from a dispute situation. Nicaragua is on the basis of the obligations owed by Germany, which is not, of course, part of the conflict in Gaza. And this is not a case where the parties had already locked horns before the United Nations or in some other forum. In the current situation, for it to be dispute a matter of substance, there would have to be some form of meaningful engagement, given which Germany indicated its position, either in Nicaragua or actually effectively understood to crystallize a dispute. It was said yesterday that the dispute described in Nicaragua of 2nd February 2024. This note was sent to the public information email address of Germany's United Nations in York, not addressed to use of official communications, not picked up until 13th February. If you note, the quote note verbal also said that the information email addresses for Canada, the Netherlands, and the United Kingdom. I understand these were likewise only picked up on 13th February, following further email sent to Nicaragua to the Netherlands. This approach, Nicaragua said at least, usually the past Nicaragua has also sent verbal to the appropriate email addresses the ambassador and assistants at German embassy in Managua, often copying in other German and appropriate email addresses. It follows that when the General Press Conference of 7th February, representative of the German Federal Office, was asked about how to receive it and how Germany intended to respond, Germany was simply not in a position to say anything material. The other press release is a judgment of 21, and in due course ask you to treat this carefully. You'll see the journalists seeing the questions correctly understood Germany, not having received any verbal. You'll also see Germany not consider itself ready to any representative position. This was not and could not be a response to resistance on the basis of a no verbal that had not been seen. Once it had received the no verbal, Germany was actively to response and seeking coordination with the 3 states that had received similar emails without warning Nicaragua commenced the current proceedings on 3rd March. There was no opportunity to engage. This is not a case like Myanmar, where the court could infer the existence of dispute following a failure to respond 1 month following the delivery of the file. In circumstances where there had already been a number of prior communications, both outside and within the UN Assembly, as could be short of views. Nicaragua thought this was fully unable to get a movement, and notably from the German note file of 11th March, said to the court after it was seized, and the court was referred. Of course, the court only concerned the ICJ, but the fact that this case is provisional measures phase cuts the weight. It is not just extraordinary resort given the jurisdiction and the exercise jurisdiction have yet been challenged. Also, relief is sought on the basis that Germany, a peace negotiation, a long time avowed support of international law, the international legal order, is breaching the genocide convention and conventional custom international law. The determination sought scarcely be serious, and relief also had, if they intended to have, direct and indirect impacts on the states not of the court. It is circumstances such as this jurisdiction prima facie demanding real charge position, clearly opposed views, not be persistent and rushable in that the box might be the best half day. Mr. Members of the court, I thank you for your attention and ask you to put the rest of the floor.
President, members of the court, it is an honor to meet you and to present my position on plausibility. This was already another case to deal with heartbreaking officers of our Gaza initiated by brutal attack on Israel. This case is not between two parties that are confronted. There is a case in which provisional measures are against the state that can choose to complicity and lack of vigilance of its other state. It is not just this case. Both legal obligations are exclusively necessarily in connection with or in response to the part of the state as the proceedings. Mr. Wolf has already demonstrated a serious military problem. This attempt to request measures against one state or reference to conduct of another state, such as possible settlement, to be in an unprecedented manner. This will first have a base of evidence that are plausible facts that are plausible violations of the part of Israel. Second, to find that there are plausible facts that are plausible part of Germany. Here, the Bible have to establish there are plausible links between Germany and the absent third state Israel. It is not a special constellation, but an expected to use the evidence legally to suggest it is Germany. However, it's practically little law, and the fact is also exclusively large and ignorance. Nicaragua claims that Germany complicit in a of international law alleged by Israel. In Article 15 application, the applicant and German accord involved in the fascination of liabilities concerning the laws of war. And Article 16 applications that Germany says will take the commission genocide because this distinct Germany's responsibility. So, the basic purpose of establishing a war was the same thing. Complicity. These purposes are the causal contribution of the actors with the wrongful act, and knowledge and intention to facilitate the wrongful act of the perpetrator. Nicaragua has not cannot write any of this should be able to be plausible. The third comment of constitutional law, as applied in international tribunals, is that the proximity, or that the breach is not too remote. Proximity is established where the consequent act is a natural and non-consequence. Such a link is especially needed to establish assistance. And the system must have contributed significantly to the wrongful act. This may be for the objective of assessing quality and efficacy of reconstruction in concrete case. Nicaragua has no evidence to how any military fraternity could make a significant contribution to the genocide of the Jewish. Given the German stringent license, there is no indication that German equipment would naturally or normally let plausible international law by itself. In addition, Nicaragua has not provided any evidence necessary subject evidence of knowledge and intent. In this case, you insist that the conduct of aid or assist or perpetrator of violence cannot read the genocide unless at least that person knowingly is was aware of the intent to tell the perpetrator. That function is not fulfilled, that is a true background of the conduct entity. Agencies must be given words and circumstances and with the intention to facilitate the course of work. Nicaragua has no evidence or potential to facilitate international rights. On the contrary, demonstrated this that it's intended to assure full respect for international law, the genocide convention, humanitarian law, or custom law. Shows the basis on new situations, and at the time during the framework and procedural limits with regard to status. These procedures have been and will continue to apply. With regard to nature aid, during the years, contrary to the in Nicaragua, it's therefore significantly believed that allegations of intent to facilitate the perpetration of national law is unfounded. Because elements of this are absent, all Germany has assisted in maintaining a situation resulting from alleged breaches of use of Israel, as Article 41, Section 2, Article 6, Article 8, are based. I now turn to the Article 1 of the Convention and on Article 1 of the Ordinance. Although, generally speaking, obligations to prevent genocide and ensure respect with IHL are indeed Germany's own obligations. Nevertheless, the emergence of the scope, its content, and possible read of such actions individually depend on. They also vary by risk to the degree and kind of wrongful acts by the state in the nation. A life obligation to prevent genocide is an obligation of conduct that has been caused. Only of us fully aware of the view of the
military that would be used to advance international law. Many of the specific conditions for the law, paragraph 67 of the Act, the first lecture that Germany has Article 1 of the Convention referred to defend genocide. In order to determine that in such breach, the court must first determine that Israel has permitted genocide. This can be seen in example of the I'm pleased that this paragraph, Nicaragua, but also yesterday, but permitted that cities are noted on the screen. That is important. In particular, I can help for breaching the obligation to prevent genocide only if it was actually permitted. The passage read out in Nicaragua is independent. It's not there is no obligation to prevention, no obligation to genocide. The commission of an internationally wrongful act. There must be an internationally wrongful act. Rule as a prerequisite on the lawfulness of the conduct of another state, in the latter's absence and without its consent. This is the so-called monetary gold principle. That principle may well apply to cases under Article 16, since it is of the essence of the responsibility of the aiding or assisting state that the aided or assisted state itself committed, and please note there the use of the past tense, an internationally wrongful act. It does suggest that the gold principle is succeeding in evidence, and it may, in a given case, already requisite prior funding, or indeed the consent of the state. The current case might indeed apply, and I'll return to the case's application shortly. Paragraph 367 for the application, each article 1 to shore, due to shore compliance, each obligation to shore, respect in all circumstances, necessarily prejudice having been aided or required respect by the state. The court knows in the genocide case applies equally in our context. There, the court explained the relation to blend the corresponding arising to the existence of a series of genocide, which is the same as how Nicaragua put forth in Article 1. But the court also explained that genocide must occur there to be a violation of the obligation to rent. So these same applies here, and it makes it for the Article 1 is the rule of due diligence, as it's just how the obligation of justification is interpreted. The basic question remains how it would be to ensure respect, if failure of us to respect is established in the first place. I would act this how, according to the option of this application in 1986, such in Nicaragua, USA. That is an intuitive result. It is entirely neutral for states to prevent the context of the conflict. It is not activity the international community seeks to do. It is only for the conduct of the conflict turns out to be a breach of humanitarian law that acts of state conflict would be expected to be ruled by. The same basis about how to set action, which is Israel denying Palestine rights to maintaining and imposing an apartheid regime. As court's jurisprudence currently is, as you say, as much trouble. Therefore, to explain, the court is not merely called on to say whether the gold should be delivered to Italy or to them. It is supposed to first the legal questions, upon the solution of which depends the delivery of the gold. So here, the court is not merely called on the responsibility of Germany. It is required first to determine the responsibility of Israel. And Nicaragua can avoid this by saying that the court defines Germany on the basis of serious risk of Israel. Correct analysis, such determination would not be sufficient to establish Germany as following the analogy of the genocide case. Anyway, so the principle makes no difference whether the required determination is actual breach or serious risk of breach. There is always essential by determination of the conduct of the state on responsibility the responsibility only depends. When meeting a court, much goal concerning the jurisdiction relating to the lunch which by are supplied in the current context. In the determination of these questions which relate to lawful and unlawful character of certain actions by Albania is Italy, only two states, Italy and Albania, are directly interested. So, substitute Israel for Albania, Nicaragua for Italy. The merits of such actions will be this dispute between Italy and Albania. The court cannot decide such a dispute because of Albania. It is not a case like now, where determinations with respect to Australia is described. Much situation of New Zealand, the court may position find that legal situation will need the basis for constitution of the rules against Australia. By contrast, our case is precisely that where the all Australia's conduct in entering into Indonesia could not be assessed Indonesia not looking as concluded the 1989 treaty. Again, currently it's not wars. Citizens of which is a basic prerequisite to consideration of the 1999 Article 36 to possession. The dispute that is relied on must exist effectively at the time the court is seized. Equal separation is one party that is opposed by another, and the dispute must hold clearly opposite views regarding the question of performance or not performance of certain international obligations. The basic fact in this case lies February to in above the letter of February, as well as a wide-ranging German governmental press conference of February. So the arguments explain the position against the dispute. It does not explain the question whether a dispute was not so substance not for. It's not a bossing exercise, but the court's very detailed consideration of parties, so there was indeed the right to dispute its jurisdiction. In consistency, the context is of critical importance. The parties are at 2 points to remove that situation, and appears in this case only is violated by government obligation by Germany. It is not, of course, a participant in the ongoing conflict of Gaza, and this is not a case where parties have already formed before the United Nations or in some other forum. In the current situation, for there to be viewed matter substance, there have to be some form of information play, pursuant to which a communicated decision, either to regular or to way that could be understood as a dispute. It was today the legal dispute was described in Nicaragua on 2nd February 2024. This note verbal was said to be public information email address of the mission of the United Nations, not the address that is used of diplomatic communication. It was not picked up until 13th February. It noted that equivalent note verbal also sent to the public information addresses of Canada and the United Kingdom. We understand it was likewise only picked up on 13th February, following a further email sent by Nicaragua to Venice. This question of Nicaragua is to say it's unusual, and indeed, the past Nicaragua has always sent to the appropriate email addresses of ambassadors and assistants to members in often copying other government missions on the appropriate email addresses. It follows that when at the ICJ conference of 7th February, representative of the German Foreign Office was asked having received a verbal and how Germany intended to respond, Germany was simply not using in the material. Because the press release, the notice holder tab and on. In due course, I asked to read this carefully. You will see the journalist asking questions correctly understood Germany as not having received a no verbal. You also see that Germany did not answer its rating the extent of its position. It was not have been a response for restoring a dispute on the basis of a no verbal that had not been seen. Once it had received no verbal, Germany had considering its response, see coordination of 3 states that had received certain emails when Nicaragua claims the receipts are. There's no opportunity to engage. And this is not a case like can be a Myanmar, where the court defer this dispute following a failure to respond one following the delivery of Nepal. In circumstances where already a number of communications with us and within the UN that show mutual views. Nicaragua assessed, but were able to point to as a most equivalent, and notably to invalid not verbal, other than much as the court it was used. That's what the relevant. Of course, what only done with decision, the fact this is a celebration of measure phase us this case. It's not just all relief is sought with the legal exercise jurisdiction and not yet been established. Also, result on the basis of Germany, a peaceful democratic nation, along the vows order of international law and international legal order, is the genocide convention and international custom international law. The determination is scarcely be more serious, and the result also has as many intended direct and indirect impacts on third states not affordable. It is precisely circumstances such as this position and message must be a positive opposition and clearly opposed views, not a specific branch or inner box might be considered as not it. Mr. President of the Court, thank you. The election is easy for.
The President of the Court, it is an honor for me to present the position of plausibility. This one has been seen in no case with heartbreaking consequences of the conflict in Gaza and Israel, but it has not been the truth of that conflict. Here is the first case of victory in which the fought against a state that is completely in and ability to protection and way that is not under the teachings. Both have legal obligations to rise necessarily if they or response to conduct was distant from the proceedings. Several of the trade also see it as a building problem. This attempt to provisional measures against one state by reference to the conduct of the state stretches the plausibility assessment to breaking point. This calls first to find a base that is plausible facts that are plausible along the trail. Second, the court have to find that all the facts that establish plausible violation of me. Here, the court will establish that there are possible or different techniques between the conduct of me and the next and third state. It is not a special solution. We have used evidence of reason to substantiate the claims against Germany. However, the argument sets little on the law and that regards the facts based exclusively regarding interferences. Nicaragua claims that complete genocide lines of humanitarian law allegedly great. Paragraph 15, the nation mentions German quote, the involvement and facilitation of non-achieved conflict of war. And paragraph 16, the outlet that Germany is facilitating genocide. And was this a distinct for Germany's response? Did not fail, because no space for dashing aid and for the same thing, complicity are lacking. These words are a contribution of capitalist wrongful act and knowledge and intention to facilitate the wrongful act of the main perpetrator. Nicaragua cannot bring evidence to the elements plausible. The central point of the law, as applied by international tribunals, is that there must be proximity, direct, of which must not be moved. Proximity established consequence of act is a normal consequence. Secondly, established agents must have contributed significantly to that act. This cannot be tried by the quality and quantity of the contribution in the concrete case. Nicaragua has offered no evidence how any of them could have made a significant contribution to the genocide of Greece or Israel. Given the trained licensing standards that scrutinize precisely the express occasion that Europe could have naturally normally the population of Israel. In addition, Nicaragua has not provided evidence of present subjective elements, knowledge and intent. In the genocide, organ or person assistance to a perpetrator of the genocide cannot be treated as genocide unless at the least that a person should mean that the same was aware of the specific intent of the perpetrator. If that condition is not fulfilled, that is to exclude the category of conduct as listed. The position of the must be with knowledge of the intent to the person. Nicaragua has not evidenced any intent out of facilitate internationally wrong. To the contrary, has that the intention to full regime will be the convention of law. Germany has legally shown on numerous occasions for this. That plan was Germany was the framework to keep in place would come out of this law. The proceedings have been and will be applied. Without 2008, Germany has converted Nicaragua increases significantly, giving us any alleged intention to facilitate the sexual development. Because the elements of A is present, all claims that are maintain a strange rule from alleged scope as well as the 1 of the statements put are equally based. Now, Article 1 of the Genocide Convention and Article 1 of the Convention. Although, generally speaking, against to genocide and to ensure the facial are indeed Germany's own obligations. Nevertheless, the emergence of the case, the scope, the exact content, and possible allegations inevitably depend on and its very reference to the degree and the kind of powerful acts by the state in the state of Israel. Unto the obligation to prevent genocide, as the context as in context. Germany's course, full of views of the
being would be used to commit many crimes under international law. Turning then to the specific declarations sought from paragraph 67 of the application, firstly, that Germany has reached Article 1 of the Genocide Convention to prevent genocide. In order to tell that that's being about each, or must first establish that Israel has committed genocide. This could be, for example, in genocide case. And note, the paragraph sponsoring the essay, but no mistake the package under the screen, despite their obvious importance. In particular, the state had held responsible for reaching the obligation to prevent genocide only if genocide was actually committed. The passage read out by Nicaragua is in place. The court there emphasises that there is an obligation to prevent genocide genocide commits. The court is clear on the need for prior finding genocide for a breach the obligation to prevent it. This is reiterated in the second line paragraph. Neither does not even aspects listed in Article 3 of the Convention, but carried out. The state permitted to act cannot be responsible. If it did not happen, which under rule out of must occur for there to be a obligation to prevent. The same basic point follows through says the court found that no genocide had taken place, and hence there not be anything for a prevent genocide of either genocide or committed genocide. To application, if then Germany aided and assisted Israel in the mission of obligations to international law, paragraphs 6 and 2 and 3. And these relations again not determined to prior termination of the Israel is unlawful. Article 16 of the ICJ responsibility, which the court considered reflective custom international law, is that with aid in the commission of international wrongful act, there must be an internationally wrongful act. The contrary further clarifies that this must be a complete act, and therefore is only confirmed by subsequent conventions subject to the jurisdiction. All those countries expressly national courts repeatedly affirmed the state to the is rule as a prerequisite for the court of another state, in the latter's absence and without its consent. This is so-called monetary gold assault. Cases under Article 16, since it is of the essence of the responsibility of aid or assistance that the aid or assistance itself committed that is past tense an internationally wrongful act. The country must suggest that the monetary gold whistle may be a barrier to judicial proceedings in case, and indeed may, in a case, be rejected by a fine or indeed the consent from the third state. In the current case, the gold does not apply, or under the case is short. So the declaration sought at paragraphs 67.3 and 67.4 of the application for breach of common Article 1 and related customary international law due to a failure to ensure compliance. A breach of the obligation to ensure respect in all circumstances is necessarily predicated on there being a lack of the required respect by the other state. The reasoning of the court in the Bosnian genocide case applies equally in the current context. There, as you see, the court explained how the state's obligation to prevent the corresponding duty to act arises when the state does existence of a serious risk of genocide, which is exactly the same as how Nicaragua portrayed the operation of common Article 1. But the court also explained that genocide must occur for there to be a violation of the obligation to prevent. Precisely the same applies here, and it makes no difference at all if common Article 1 is considered all the due diligence, as that is just how the obligation to prevent under the Genocide Convention is interpreted. The basic question remains, how can it be failure to ensure respect of a third state if the failure on the part of that third state to respect is not established in the first place? I would add that this is how the court envisaged the operation of this obligation in 1986, both in Nicaragua and USA. And that is also the intuitive result. It is entirely useful for one aid to support the context of an armed conflict. This is not an activity that the international community really seeks to deter. It is only if the conduct of the conflict turns out to be in breach of international humanitarian law that the acts of the state offering support would be expected to be ruled upon. Same basic points under paragraph 67.5 of the application, which is predicated on Israel denying Palestine's right to self-determination and maintaining and imposing an apartheid regime. As the court's jurisprudence, the current case is substantially the same as the monetary gold. There, the court explained, the court is not merely called upon to say whether the gold should be delivered to Italy or to the United Kingdom. It is requested to determine first the legal questions, of the solution of which depends on the delivery of the gold. But just so here, the court is not merely called upon to pronounce the state's responsibility to Germany. It is required first to make determinations of the responsibility of Israel. And you cannot want this by saying that the court can find breach by Germany on the basis of serious risk of breach by Israel. On the correct analysis, such determinations would not be sufficient to establish breach by Germany, as follows the analogy of the Bosnian genocide case. But anyway, the matter of principle, it makes no difference whether the required determination is of actual breach or serious breach. There is still essential prior determination of the conduct of the third state, on which the responsibility of the respondent state wholly depends. The consequent reasoning of the court in Montreal concerning the absence of jurisdiction regarding the underlying issue of breach by Albania thus finds in the current context. In the determination of these questions relate to the lawful or unlawful character of certain actions by Albania vis-à-vis Italy, only two states, Italy and Albania, are directly interested, with Serbia substituting Israel for Albania and Nicaragua for Italy. To go into merits of such questions would be decided dispute between Italy and Albania. The court cannot decide such a dispute without the consent of Albania. This is not exactly narrow, but determinations with respect to Australia's conduct merely might have implications for the situation UK and New Zealand. And the court was in a position to hold that no finding in respect of that legal situation will be needed as a basis for the court's decision on Nauru's claims against Australia. By contrast, the current case is precisely analogous to East Timor. Portugal's claim, as it unlawful Australia's conduct in the 1989 treaty with Indonesia, could not be asked without first entering into the question why it is that Indonesia could not lawfully conclude the 1989 treaty. Again, our case is on all fours. In the existence of a dispute, which is a basic prerequisite for consent to jurisdiction of both Article 9 of the Genocide Convention and Article 46 of the Court Statute. Dispute that is relied on is at the time the court sees. The establishment need to claim one party is positively opposed to another. The two sides must hold clearly opposite views concerning the question of performance or non-performance of certain international obligations. This lies 3 February 2024. The note of the letter of Secretary, as well as the experts from a wide-ranging governmental press conference in February 3rd, in claim publication is due. The court has explained the question of what is not one before. It's not a box in advice, as species of very detailed consideration in past cases, so whether there was indeed required dispute respect to the jurisdiction. In considering substance, the contrast the critical importance. The current parties have 2 points over the bilateral dispute situation. Nicaragua appears in this case only as alleged by its obligations to both parties, which is not, of course, a participant in the ongoing conflict in Gaza. This is not a case that parties have already locked horns before the United Nations in some other forum. In the current situation, whether dispute natural substance will be some form of meaningful gain, will claim that the Germany communicated its position in Nicaragua or in such a way that it objectively understood across the dispute. It was yesterday that the legal dispute was described in Nicaragua's Conflict 24. But this note was to the public information service of Germany's permanent mission to the United Nations, not AS, as used for official investigations. It was not picked up until 13th February. Equivalent note verbal were also sent to the public information email addresses for Canada